Hey everyone, Angela Langlotz, business law and trademark law attorney here with some more trademark talk. That's what I've decided to call this. I'm sure it wouldn't serve as a very good trademark, but nonetheless, that's what I can call it right here to y'all. So I am going to tag Rob Ansbaugh in this because he asked a question about a video that I did last week about Better Burger and how Better Burger isn't really good as a trademark because it's merely laudatory. Actually, no, it wasn't Better Burger. It was Breakfast Burger. Better Burger was yet another previous episode. Look for that in the episode archives. Anyway, what Rob wanted to know is, he said, can Carl's Jr. sue another burger place over the use of Breakfast Burger if Carl's Jr. is using the trademark, but it's not registered? Well, yes, anybody can sue anyone for anything. Likelihood of prevailing, probably not super high, but it's a teachable moment, so let's talk about it anyway. So if you are using a very descriptive trademark like Breakfast Burger, it's so descriptive that it's almost generic, right? You're going to have a really hard time suing to enforce your exclusive right to use that trademark because it's so descriptive. Now, normally, if you had a trademark that was a better trademark, but you didn't have it registered, yes, you can sue to enforce that trademark. There's some obstacles that you're going to have to overcome, however. Because it's not registered, you're going to have a whole bunch of stuff that you have to prove. You're going to have to prove that you're the true owner of the mark. You're going to have to prove that your mark is being infringed. And keep in mind, when you have a common law trademark, you only have rights in the geographic area where you're actually using the mark. So it may be that your competitor, whom you are suing, may have better rights to the mark in their geographic area. You don't know. This is why it's important to register your trademark with the United States Patent and Trademark Office if you would like to have the exclusive right to use the mark and prevent others from using it. You're also going to have to prove that you were the first user of the mark in your geographic area, and you might have some problems proving that. If you have a registration, in contrast, you are presumed to be the best owner of the mark. You're presumed to be the true owner, and you're presumed to have used the mark at least as early as the date that you claim in your application. So one of the reasons why I like people to register their marks, besides the fact that I get paid to do it, is because you actually get a lot of benefits from registration. And it makes it so much easier when you go to enforce your mark. If you can say, listen, I own trademark registration, blah, 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 whatever the number is, and you're infringing my mark, please stop. If you don't have a registration, all you can say is, hey, I think you're infringing my mark. I was using it first. Stop. Guess what they're going to do? If they don't rush out right away and file their own trademark application, claiming use earlier than you claim, they're just going to say, well, tough. We were the first user. And then you get into a big old fight. And big old fights are very expensive. So to avoid big old trademark fights and secure your rights to use the mark exclusively that you want to use, I suggest highly that you take a little preventative medicine and file and register a trademark with the government. You can find me online at TrademarkDoctor.net. You can like my Facebook page. It's called Trademark Doctor, facebook.com/TrademarkDoctor. And you will be notified every time I go live. I do these every weekday at whatever time I feel like doing them. And you will be notified every time I go live so you won't miss anything. So register those trademarks, folks. Ciao.